Well, damn it. I just realised I haven't been prefixing my videos with a disclaimer. So let me start there. I'm not a lawyer. I'm just a layperson who knows how to look up case law and match it to the circumstances that the case law is applicable to. But I don't know all the circumstances. I'm not privy to the muted sidebars, or the dressing down in the judge's chambers, and the mountains of sealed documents. So how applicable the case law is a whole other question that only the lawyers who are privy to those things can make determinations on. As I've said in other videos, I'm just here considering all of the possibilities. That doesn't necessarily make them probabilities. And without all the background information that I just mentioned, all my videos amount to is a research exercise. Nonetheless, I still want to try and answer some of the questions that you have, because more often than not, they're questions that I'm asking as well. So when I find answers that satisfy my own curiosity, I'm going to tell you what my answers were, and hopefully they satisfy your curiosity. In this video, we're going to talk about all the possible outcomes, because a lot of people have either asked about them or speculated about them, and sometimes it's difficult to understand where the federal law starts and ends and the state law starts and ends, and what you do with the overlaps. Let's kick this video off with, what is the purpose of the last 6 videos? We've essentially been looking at all of the issues raised to date since pre-trial motions before trial 1.0 and diving into those issues individually. Each one has its own set of possibilities as far as case law is concerned. But the overall point of the exercise is looking at the cumulative effect of the issues raised in relation to the habeas petition. And as a whole, they demonstrate a systemic violation of Karen Read's constitutional rights under the 5th, 6th and 14th Amendments. Each violation, when considered on its own, already raises serious due process concerns. However, when viewed as a whole, these issues can magnify each other, creating a situation where the trial process can be seen as fundamentally unfair and unconstitutional. With respect to the habeas petition actually filed, we know it's raising a single issue of double jeopardy. However, under federal habeas law, a petitioner does not need to prove that any single issue alone would have changed the verdict. Rather, if the cumulative effect of multiple constitutional violations deprived the petitioner of a fundamentally fair trial, habeas relief may be warranted. Key habeas precedents include Taylor v. Kentucky, 1978. A defendant is entitled to a fundamentally fair trial, and multiple errors that together create unfairness can warrant habeas relief. Also, Chambers v. Mississippi, 1973. Even if individual errors seem minor, their collective impact can result in a due process violation requiring federal relief. As we've learned, can and may doesn't necessarily mean it will. The point is, if you want to make such arguments in your petition, then you need to preface it with the applicable case law that supports your argument. You can stand there and complain all you like to the judge about this isn't fair, that's not fair, but you absolutely have to show the judge which law applies to the arguments that you're making. Because essentially, if the judge is making rulings that have no legal standing, it's essentially ultra vires. This is a Latin phrase that means beyond the powers, and it describes an act that requires legal authority but is done without it. So you will often hear judges say, what is the legal authority that you would like me to make a ruling on? And when you cite case law, you are giving them that legal authority, from which they can make a decision based on their legal authority to do so. While we're on that topic, let's address when a state introduces instructions, guidelines, statutes, or standards that are unconstitutional. To understand this, you need to wrap your head around the hierarchy of laws. So, just to break it down into the most basic language that I can, common laws are the laws that apply to you and me, the citizens. Federal and constitutional laws are the laws that apply to the government and the states. In most common law countries, there are safeguards in place to ensure that the common laws the states or the government want to introduce don't overextend or abuse their power. In Australia, the doctrine that protects us from the government or the state abusing their power is Section 109 of the Australian Constitution, which provides if a state law directly conflicts with a federal law in a way that makes it impossible to comply with both, the state law is considered inconsistent and rendered invalid to the extent of that inconsistency. Put simply, if a state creates a law that's in conflict with federal law, then the latter shall prevail. This is a provision that all common law countries that like to call themselves a democratic, just society must have in place, but different countries provide it in different manners. So in the US, the equivalent provision would be the Supremacy Clause. It's Article 6, Clause 2 of the US Constitution, which essentially says that the judges in every state shall be bound by the supreme law of the land. And it's essentially applied in the same way. When state law conflicts with federal law, then the latter shall prevail. And of course, federal law includes our constitutions. The US isn't quite as black and white as that. There's a different way that it's applied in this particular situation, but that's essentially the hierarchy. So when Judge Bev says, in Massachusetts, blah, 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 it's not quite as cut and dry as she makes it out to be. It depends entirely on whether what she's saying is in conflict with federal legislation or US Supreme Law or the Constitution and so on. And so just to tie this back to the Habeas petition, it's concerned with the US Constitution, where federal case law is the appropriate mechanism to challenge the Massachusetts state law that is in conflict. Getting back to the cumulative impact of the issues that we've covered so far. Starting with the jury foreperson issues, which are involved with selection, bias, and suppression of acquittal votes, which are related to due process and protected by your constitution. So what we uncovered is 1, that Judge Canoni improperly selected the jury foreperson instead of allowing the jury to choose. This is inconsistent with the federal case law protecting jury independence. 2, the jury foreperson had prior knowledge of a dismissed grand jury indictment against the defendant, which was never introduced as evidence in front of the jury, but may have influenced deliberations. 3, the jury foreperson suppressed acquittal votes on 2 charges and failed to report them to the court. And 4, after the trial, the jury foreperson, aligned with the prosecution, submitted an affidavit supporting the state's narrative and requested juror identities be sealed. The relevant case law that we uncovered during that video included McDonough Power Equipment versus Greenwood, 1984, which says juror misconduct affecting deliberations invalidates a verdict. And Remmer versus United States, 1954, which says any outside influence on a jury is presumed prejudicial. The cumulative impact of these issues includes the improper selection of the foreperson, which ensured a biased juror was in control of deliberations, and the foreperson actively influenced the verdict by preventing proper reporting of acquittal votes, which tainted the jury's ability to reach a fair and independent decision. In summary, Judge Canoni's single act of choosing the jury foreperson in itself is neither here nor there, but the fact that it led to all of these other due process violations is what the federal court would be focusing on. Let's move on to judicial bias and prejudicial courtroom conduct. 1. Judge Canoni allowed organic references to witness intimidation allegations, even though both the prosecution and the defence sought to exclude them. 2. Judge Canoni publicly removed an alleged co-conspirator in that witness intimidation from the courtroom. I'll just correct myself here, it wasn't in front of the jury. But we do know from jury comments post-trial that they did hear about his attorney being forced to address it, giving the appearance of credibility to an otherwise dismissed charge. And 3, judge can only overrule key evidentiary motions to exclude highly prejudicial material that was unrelated to the charges. The key case law that applies here is Bracey v. Gramley, 1997. It says judicial bias is a valid basis for habeas relief. And Shepherd v. Maxwell, 1966, which says public courtroom spectacles that prejudice the jury violate due process. The cumulative impact includes the judge's conduct improperly reinforced a prosecution narrative that was legally dismissed before trial. Her public removal of a courtroom spectator created the impression that the defence was engaged in misconduct, and by overruling both parties' agreement to exclude references to witness intimidation, she unfairly tilted the trial against the defence. Well, this is a good topic, the prosecution's misconduct. We've already heard multiple motions to dismiss, and we know that one's pending, possibly even due today or tomorrow for America. So you can add all of the details in those motions to dismiss to these due process violations that we uncovered in previous videos, including 1, the prosecution introduced a clearly doctored video into evidence mid-trial, which was never disclosed to the defence beforehand. 2, the prosecution withheld key evidence until trial was well underway, violating discovery obligations. 3, the prosecution sought to sanction the defence for late disclosure of a witness, even though the state engaged in far more egregious discovery violations. The case law that supports these arguments is Brady v. Maryland, 1963, prosecutors must disclose exculpatory evidence, and Napieu v. Illinois, 1959, knowingly presenting false or misleading evidence violates due process. The cumulative impact includes prosecution engaged in unfair trial tactics that disadvantage the defence while benefiting from judicial favouritism. The doctored video and last-minute evidence dumps compromise the defence's ability to respond effectively. And the prosecution's inconsistent application of discovery rules violated due process by holding the defence to a higher standard. All these issues bring us to a pattern of systemic due process violations. Individually, each of these issues might raise concerns, but collectively, they establish a pattern of constitutional violations that ensured an unfair trial. The combination of juror misconduct, judicial bias, and prosecutorial misconduct created a situation where fair trial was impossible. The key cases to cite are going to be Taylor v. Kentucky, 1978. The totality of unfairness can warrant habeas relief, even if no single issue is decisive. And Chambers v. Mississippi, 1973. A trial infected by multiple due process violations is constitutionally invalid. The cumulative impact on the habeas petition includes the jury foreperson's misconduct guaranteed an unfair deliberation process. 2, the judge's rulings consistently favoured the prosecution, reinforcing an unconstitutional bias. And 3, the prosecution's discovery violations and evidence manipulation ensured an uneven playing field. Hopefully by this point you're understanding what cumulative impact means. Any one of these issues, when viewed independently by the federal court, may not raise enough concern, but all of them together add to the totality of the unfairness. Even if you assume I'm wrong on 1 or 2 of these things, and that perhaps other case law might contradict the case law that I've cited, it still comes back to the totality of the unfairness. So even if we do drop 1 or 2 things, we still got a fair bit for the federal court to consider. And that's not including everything that was included in the dismissal motions. So let's wrap up with why everything can be included in the habeas petition. Under federal habeas law, a petition may seek relief if the cumulative effect of multiple errors denied the defendant a fair trial, That's under Taylor versus Kentucky. The trial judge's conduct displayed favouritism, violating the 14th Amendment, which is under Brady versus Gramley. The jury's deliberations were tainted by bias and external influences, covered under McDonough versus Greenwood. And the prosecution engaged in misconduct that materially affected the outcome. That's covered under Nepew versus Illinois. Additionally, the key federal habeas precedent that would apply is Kyles versus Whitley 1995. It says the cumulative effect of prosecutorial misconduct, juror bias, and judicial impropriety may require a new trial under federal habeas review. The thing is, we already got a new trial, so if that's the only outcome we can expect, then it seems really pointless, right? Not so fast, Grasshopper. Push a pin in that and we'll come back to it. Essentially, the conclusion we should be drawing is that this case presents a clear due process violation under federal habeas law, because each of the issues raised when considered together demonstrate that the petitioner was denied a fair trial, and that under federal habeas precedent, the collective effect of multiple constitutional violations warrants relief. The habeas petition should present these issues in a cumulative manner to illustrate the overall unfairness of the trial. Questions have asked us how these things would be presented since the habeas petition's already submitted. We'll come back to that as well. Let's first address the matter that we just push-pinned. If a second trial is already underway due to Judge Cannoni prematurely calling a mistrial being the main issue described in the habeas petition, we have to remember that it's addressing the double jeopardy clause, specifically seeking to bar retrial on counts 1 and 3, not requesting a new trial. The primary issue in the habeas petition is that Judge Cannoni improperly declared a mistrial, leading to the current second trial. The federal court now has several potential forms of relief, including barring retrial for counts 1 and 3. And that's because the federal court has broad discretionary power to remedy constitutional violations, and its decision will depend on whether it finds 1. The mistrial was improperly declared, violating the double jeopardy clause of the 5th Amendment and/or due process under the 14th Amendment. 2. The cumulative effect of judicial bias, prosecutorial misconduct, and juror misconduct denied the defendant a fundamentally fair trial, which is essentially due process under the 14th Amendment. What could this relief potentially look like? A stay of proceedings is probably going to be in order whether we add all of this extra stuff or not, or if the federal court finds that the mistrial was declared in error, it may issue an injunction to stop the second trial. Key habeas precedents that support this would be Ex parte Lang, 1873, where the Supreme Court held that if a trial court improperly terminates a case, retrying the defendant may violate double jeopardy, and United States versus Jorn, 1971, where the Supreme Court ruled that if a judge declares a mistrial without manifest necessity, we're all familiar with that because that was a key phrase in the SJC appeal, as well as a key phrase in this habeas petition. It goes on to say, then a second trial may violate the double jeopardy clause. So if Judge Cannoni prematurely declared a mistrial without sufficient legal grounds, the second trial may be unconstitutional, and the federal court may order a stay to halt the trial pending resolution of the habeas petition. Or they may just do that anyway because it's getting very close to the trial date. I guess it depends on how long it takes to get all these things in place at the federal court. Either way, I think a stay of proceedings is probable. Not just possible, but that's just my opinion and I'm not a lawyer. Another outcome that is possible is a writ of prohibition to prevent further prosecution. If the federal court determines that a second trial violates the defendant's constitutional rights, it may issue a writ prohibiting Massachusetts from continuing the prosecution. This falls under case law Downham versus United States, 1963, where the Supreme Court ruled that if a mistrial is declared due to judicial or prosecutorial error, retrying the defendant may be unconstitutional. And Oregon v. Kennedy, 1982, if a mistrial was caused by judicial or prosecutorial misconduct, double jeopardy protections may bar a retrial. So if Judge Cannoni's decision to declare a mistrial was premature, unnecessary, or motivated by bias, the federal court may prohibit Massachusetts from continuing the second trial. So the question would be, period, or just for counts 1 and 3? Pushpin that, we'll come back to it. Another possible outcome could be immediate release from custody or pretrial supervision. Currently, we know that Karen's out on bond, and that the McAlberts would love nothing more than to have her bond revoked. So under this relief, if the federal court finds that the second trial is unconstitutional, it may order the petitioner's immediate release. This falls under Habeas case law, Fay v. Neuer, 1963. The federal courts have the authority to order a defendant's immediate release if continued detention violates constitutional rights. So this is applicable if the second trial is unconstitutional, then the federal court may order the immediate release of the petitioner and prohibit Massachusetts from retrying the case. Another possible outcome could be evidentiary hearing based on judicial misconduct. If the federal court is concerned about Judge Cannoni's conduct, it may order a hearing to examine whether she engaged in judicial misconduct warranting federal intervention. This falls under Brady v. Gramley, 1997, and we've already talked about that one. If evidence shows that Judge Cannoni deliberately manipulated the trial process to force a mistrial, then the second trial may well be invalid. And finally, they could declare the second trial unconstitutional and order a dismissal with prejudice. So in the case where the federal court finds that the Massachusetts courts violated double jeopardy protections, it may dismiss the case with prejudice, barring any further prosecution. This falls under Case Law Arizona v. Washington, 1978. A mistrial must be based on a manifest necessity, and if it is not, retrying the defendant may violate constitutional protections. And Evans v. Michigan, 2013, if a mistrial is declared without legal justification, retrying the defendant is unconstitutional. Of course, this kind of outcome would rely on Judge Cannoni being found to have no valid reason to declare a mistrial, in which case the federal court may dismiss the case with prejudice. The case, the whole case, or counts 1 and 3. Again, keep that pinned because I am coming back to it. So quick summary, all of the potential relief that's possible: a stay of proceedings, which I think is likely, a writ of prohibition for counts 1 and 3, immediate release from pre-trial conditions, an evidentiary hearing, either for the manifest necessity or for everything, including all the extra stuff, and or a dismissal with prejudice for counts 1 and 3. The federal court can find relief for one, all, some, or none. Again, I'm not a lawyer, so I don't know which ones would be more likely than others. So how about that one we've been putting a pin in for a bit now? The Habeas petition seeks relief from retrial for 2 of 3 counts. But could the federal court bar retrial on all counts if it finds serious enough violations? The straight answer is yes, because the federal court has that jurisdiction. If it finds that the trial process was tainted by serious constitutional violations, such as judicial bias, prosecutorial misconduct, juror misconduct, or double jeopardy, or all of the above, it does have the authority to bar retrial on all counts, even if the habeas petition initially only sought relief for 2 of 3 counts. Yay! Excuse me while I have a little party in my seat. A girl's got to have hope. The key legal authorities that give the federal court the broad power to remedy constitutional violations are USC 28, Section 2243, the habeas corpus statute. Federal courts have discretion to dispose of the matter as law and justice require. The double jeopardy clause of the Fifth Amendment, if a mistrial was improperly declared or caused by a state misconduct, retrial may be unconstitutional. And then due process of the 14th Amendment. If a trial is fundamentally unfair due to multiple constitutional violations, the conviction and retrial can be invalidated entirely. So be careful what you wish for, D.A. Morrissey. So the next question is, when can the federal court extend relief beyond what is requested? A federal court may bar retrial on all counts, even if the habeas petition originally sought relief from only two, if it finds that 1. The entire trial was structurally tainted, meaning that the defendant never received a fair trial on any count. 2. Judicial or prosecutorial misconduct infected all charges, making a fair retrial impossible. 3. Double jeopardy applies due to an improperly declared mistrial. And 4. Juror misconduct fundamentally compromised the integrity of deliberations on all counts. These all fall under key Supreme Court precedents. Burks v. United States, 1978. If a conviction is overturned due to insufficient evidence, retrial is barred under double jeopardy. Arizona v. Washington, 1978. A mistrial must be based on manifest necessity, otherwise retrying the defendant violates the Fifth Amendment. Oregon v. Kennedy, 1982. If a mistrial was declared due to prosecutorial misconduct or judicial misconduct designed to provoke the defence into seeking a mistrial, double jeopardy applies. Let me repeat that for impact. If a mistrial was declared due to prosecutorial or judicial misconduct designed to provoke the defence into seeking a mistrial, double jeopardy applies. And what was it that the prosecution argued to the SJC? Successfully, I might add, that the defence appeared to be seeking a mistrial prior to the judge calling it. I have yet to comb the habeas petition for references to case law precedent to see what they're arguing specifically, but if I were presenting it, this one would be a must-have. Because if Judge Cannone prematurely declared a mistrial on all counts due to misconduct or bias, then retrial on any count is going to violate double jeopardy. Additionally, if the jury foreperson's bias and suppression of acquittal votes compromised the entire trial, then no charge was fairly deliberated. And also, if evidence was tainted by prosecutorial misconduct, such as the introduction of doctored evidence or discovery violations, this affects all counts. And that is precisely what I'd be arguing for all the misconduct, all of it, even the weak ones, because the cumulative effect invalidates the entire trial. Even if some charges were stronger than others, the federal court may find that the entire trial process was so compromised that no count can be fairly retried. In Taylor v. Kentucky, 1978, the Supreme Court ruled a defendant is entitled to a fundamentally fair trial. If multiple errors cumulatively deny due process, retrial is barred. So that would include 1. The jury foreperson's bias and misconduct, where the jury foreperson suppressed acquittal votes and had prior knowledge of a dismissal indictment, making all deliberations tainted by prejudice. 2. Judicial bias and prejudicial courtroom conduct, where Judge Cannone's overruling of agreed-upon motions, public removal of an alleged co-conspirator, and selection of the jury foreperson before eliminating alternates indicate systemic bias. And 3. Prosecutorial misconduct, where the prosecution introduced doctored evidence mid-trial, delayed key disclosures, and sought sanctions against the defence while committing more serious discovery violations, all covered under Kyles v. Whitley, 1995. Cumulative errors can render a trial fundamentally unfair, justifying habeas relief. The federal courts may bar retrial on all counts if they determine that the trial process was so corrupt that retrying any charge would continue the constitutional violations. You have to remember, we're not claiming extraordinary government misconduct in a vacuum. We actually have federal government support in making these claims. While Auntie Bev, the Commonwealth, and the defence don't have the power to compel the FBI to tell them what they're investigating, the federal courts do. They have the power to compel a quiet conversation between the court and the FBI, or they have the power to subpoena the FBI, or whatever they have to do to find out the nature of that investigation. So like I said, be careful what you wish for, DA Morrissey. Whether you go about it the way I'm suggesting, and you just lay it all out on the table, here's what we've got, or you slip in there on the side that the federal court should investigate themselves, either way, if they come to the conclusion that the first trial was fatally tainted, thus structurally defective, it may dismiss the case entirely on all counts, even if some counts were initially excluded from the habeas petition. This falls under United States v. Young, 1985. If government misconduct undermines confidence in the outcome, retrial may be barred as a due process violation. Whether it comes down to DA Morrissey's misconduct or Judge Beverly Cannoni's rulings creating an inherently unfair trial, juror misconduct undermining deliberations, then it's all tainted. And if a second trial is proceeding under the same flawed judicial oversight, then the entire retrial should be enjoined, which means stopped. So just to recap the potential relief if violations are serious enough, it could be dismissal of all charges with prejudice under the legal basis of double jeopardy. It could be a stay of the second trial under the legal basis of habeas corpus powers. It could be a writ prohibiting further prosecution under the legal basis of due process and judicial misconduct. And or it could be evidentiary hearing on the judicial misconduct. Again, it could be all, some, or none, but would the federal court automatically consider all counts? The federal courts have the authority to expand the scope of habeas relief if they find that constitutional violations apply broadly to the entire case. If the second trial is tainted by the same due process issues, the federal court may order an immediate injunction on all charges. This falls under Strickland v. Washington, 1984, where habeas relief is warranted when the entire trial process was compromised in a way that undermines confidence in any conviction. So, here's the key takeaways. The federal court can bar retrial on all counts if it finds widespread due process violation. It's not limited to the 2 counts identified in the habeas petition. It can bar retrial on all counts if the entire trial process was unconstitutional. If Judge Beverly Cannoni's mistrial declaration was improper, retrial on any count may violate double jeopardy. If judicial bias, juror misconduct, and prosecutorial misconduct cumulatively tainted the first trial, the second trial cannot proceed fairly. The federal court can grant border relief then requested, including dismissal of all charges with prejudice, if we're lucky. And again, I'm not a lawyer, so I don't know if an all-in approach is the best way to go about this. But I'll tell you who does know, Marty Weinberg. He may well know exactly how this is going to go down once the federal court reads certain dismissal motions, which could potentially trigger this whole process without throwing the whole bag in the kit. But at the end of the day, at least we all know what's possible now that the federal court is looking into things. And sometimes all you need to know is the paths that you could take instead of being blind and not knowing what's in front of your feet. I hope you found it as helpful as I did.